Family Business Network North America. Welcome to our webinar today, Clear as Mud, Trusts, Trustees, and Beneficiaries. We're delighted to have you joining us for what will be a very interesting conversation about trusts and their role in the family business and family wealth context. We'd like to send out a special welcome to our new members and to our members from outside the U.S. who are joining us on this webinar. It's great to have you with us. And we hope we'll have you with us for future webinars and future programs, which we'll talk about at the end. I'd like to start by introducing our speakers for today's session. The first is Allison Comstock-Moss, who is a Principal and Vice President of Comstock. Allison joined Comstock in 2001 and in 2008 became a member of the board and a principal at the firm. She works with individuals, families, and nonprofits through strategic planning and portfolio preservation and wealth transfer to the next generation. She's a member of the Endowment Advisory Committee for Child Advocates and is the co-founder of Purposeful Next Gen Collaboration. She also serves on the board of directors for the Planned Giving Council of Houston and earned her bachelor's degree from Brigham Young University. Kristen Keffler is a business and leadership coach who supports the next generation and affluent families to build courage and pursue their own big ideas by developing business skills and life skills to successfully translate big ideas into reality. She has published articles and had interviews in a number of publications, including the Journal of Financial Planning, the Journal of Practical Estate Planning, Entrepreneur Magazine, the Denver Business Journal, and the Business Altitude Magazine. She's the president and board of directors of the Boulder Youth Body Alliance, a nonprofit organization that helps teens become peer educators and policy advocates around the issues of positive self-image and body empowerment. So we have a very distinguished group here to help us delve into this topic of trusts and trustees. So with that, I will hand it over to our speakers.
Thank you so much. Yeah, thank you, Andrew, and thank you to all of the Family Business Network members who are with us today. I want to start off, this is Kristen, and I want to start off and just give you guys a roadmap of what we are going to be looking at and talking about during today's webinar. I also want to invite you to submit any questions you have through the chat room, the chat availability on the GoToWebinar. So feel free to send any questions that way. Alice and I will address them as we go through the presentation. If we don't get to them, we will hold time at the end of the presentation for them. So today we're going to be looking at a couple of key objectives. First, we want to talk about the duties and responsibilities of both the trustee and the beneficiary, and to really drill down to some of the key things that that are important when looking at this relationship that has some ages-old challenges to it, and we really want to highlight where the opportunities are in that trustee-beneficiary relationship and that dynamic. And in order to do that, you have to understand the law, the liabilities, and the current trends that are present in the trust state right now, and also recognizing the importance of trust and building relationships between the trustee and the beneficiary, that so often these can be at worst contentious relationships, and sometimes at best just not much of a relationship between trustees and beneficiaries. And Alton and I really are strong advocates for beneficiaries becoming empowered and engaged and learning what they need to do to hold up their end of the bargain, and also educating trustees on what it's like to sit on the other side of the table and learn a language that you don't often know, and to be in a situation that can be very new and unsettling, and that is being in the position of a beneficiary. So that's what we're going to be focusing on first today. But before we actually dive into some of that content, I want to start by setting the stage for where the idea of a trust actually came from. This is something that in our language today, and particularly in the language of trust and estate, and where we're working with affluent families or families in business, we throw the concept of trusts around a lot, and I don't think that very often we have an understanding of where that concept actually first originated from. I know that I actually didn't. So the concept of the trust actually originated during the Crusades, hence the Crusade-like photos in front of you now. And the idea was that English knights would go off to war knowing that they would be gone for a long time. And many of them knew that they would probably not survive and return home. So the knight would ask someone that he trusted, and quite often this would be a bishop or someone of status in the community, to look after his property. So the knight would instruct his trustee on how to manage the property and what to do with the property should the knight not return back from war. So the nature of trust, where someone is transferring property to someone else to manage on behalf of another person, hasn't changed much over the years, but that's where the genesis of the idea of trust began. It's really about the transfer of property and somebody holding one person, transferring that property to another person to hold on behalf of a third person. And so you can see how that plays out in our modern trust structure and with the modern trust players, which we'll talk about a little bit more later on in this presentation. So the first question that comes to mind is, why would anybody give up control of their assets to someone else? And some of you may experience this in your own family dynamics or maybe in professional dynamics. You've seen how this kind of relationship, having somebody, a trustee, hold assets on behalf of someone else can create a lot of challenge on all sides. And so I want to start by talking about why would someone ever give up control of their assets to someone else. And so there's some really key benefits to having a trust, to putting assets into trust. And the first one, this is the one that most people know about, is the protection from creditors. And so this is the creditors of the beneficiary. So this could be anything, including divorce, other lawsuits. So everything that is held in trust has certain levels of protection. And so very often when one person is putting money into trust for someone else, they are thinking about how to best protect those assets for that beneficiary. The second one is the UPIA requirements. And UPIA is the Uniform Prudent Investor Act. And basically what UPIA does is it requires diversification of an entire portfolio, not just the individual investments. And thus it results in less volatility. And all trustees are bound by the UPIA Act are bound by UPIA because of their role as fiduciary. So the reason that this is important is that if you give money to a beneficiary and you want it to be available for a long time, you don't want a trustee making big bets with it and putting something in a highly volatile stock or doing anything with those assets that isn't prudent and isn't being governed in some way by some agreed upon prudence around the investing. So the investing of those assets. So one of the things around UPIA that I do want to mention is that a trust can actually have it be stipulated that it can be concentrated, but this is a very specific case. And Allison, you actually had a great example with this when you and I were talking about this the other day. Would you be willing to share the example that you had?
Sure. Some families have legacy stock, and so down here in Houston, a real common one is ExxonMobil. And you can absolutely justify a concentrated position in a stock like ExxonMobil because the company itself is so diverse. And so we've seen where the court has withheld or upheld the trustee's decision to stay in a concentrated position because of the diversification and lack of volatility that concentrated position presented for the trust. So there are exceptions. And then, of course, if the trust stipulates in the document that it can hold a concentrated position, then the document rules over that.
Perfect. You said that so well. Thank you. Another one of the benefits of putting assets in trust is that trust assets are not subject to probate. And as many of you probably know, probate is the first step in administering an estate and resolving all claims against that estate and distributing assets according to the will. And trusts that were funded during the settlor's or the grantor's lifetime are not subject to probate at the time of his or her death. Now, that's not true if the trust is actually funded at the time of death. Then the assets that fund the trust are subject to probate because they're part of the estate. But any trusts that were funded by assets during the settlor's or the grantor's lifetime are not subject to probate. So that offers an extra form of protection to them as well as an expediency. They just don't get stuck in that process. And then finally is around the reduction of emotional or undue influence on investment decision making. And this is because the trustee is a fiduciary and can be sued if he or she isn't honoring the trust and making the best decisions on behalf of the beneficiary. And so the trustee then, because they are making decisions for assets in a trust, has to remove the emotional decision making out of how those assets are being invested, and therefore it's more prudent and set up to be more beneficial for the beneficiary.
And I would add to that.
Oh, yeah, go for it.
Chris, and I'd add to that too that while ideally it reduces emotional or undue influence, there are certainly plenty of exceptions, but it also reduces the emotional influence that the beneficiary might have if they were in charge of making the investment decisions. And where we've seen a huge loss of wealth from generation to generation, it is when a beneficiary is perhaps uneducated or unexperienced in investing and will go and place big bets or trust people without proper due diligence, and then later we see huge losses of wealth. So there's a lot of protection for the assets that are placed in trust in all four of these areas.
Very, very good point. Thank you for jumping in with that, Allison. So I think it's really important to understand, now that we've talked a little bit about the benefits of why someone would put assets in a trust, I want to talk about who the players in a trust are. And this may seem very elementary for some of you. I know that with the extensive amount of work that I do with people who are beneficiaries in their 20s and 30s and 40s, there's often an assumed level of knowledge that they'll have because they've grown up in this world of affluence and where this kind of language is thrown around more regularly. And so we often assume that they know more than they actually know, and that's a huge disservice. And so I want to start with the basic building blocks, and then Allison will start diving in more deeply to some of the subtleties around these. So there's some key players in every trust. And the first one is the settlor or the grantor. And this is the person who originally creates the trust. So they're the ones who will contribute the assets to the trust. They will create the letter of wishes so that it's clear what their intent was. And so this is one obviously very key player. Another key player is the trustee. Now the trustee has a fiduciary role, which means that they're legally responsible for taking care of the assets that are in the trust that have been entrusted to him or her. Very often, and this doesn't have to be, but very often, and this is becoming more of a trend now, there's also a trust protector. And the trust protector is usually put in place by the settlor, and they are there to make sure that the letter of intent, the spirit of the trust, are being adhered to by the trustee. So they're really there just in a role of oversight, sort of a place for checks and balances. Now the trust itself is an entity. The trust owns the assets that the settlor have funded it with. And then third, or finally, we have the beneficiary. And the beneficiary is obviously the one who gets the benefit of those trust assets. Allison, do you have anything to add to those pieces and parts?
Yeah, let's add then the next layer of who the real players are. And I say that because while on paper it may just be the settlor, trustee, trust beneficiaries, and protector, but in real life there's far more people involved. And so we wanted to divulge that because this is something that can cause a lot of complication to something that on paper is relatively simple and straightforward. And that was part of our objective today, is recognize some of the challenges and trends that we're seeing in the trust world today. One of those in green here on the left you'll see is institutional. And that's when the trustee is a third-party corporate trustee. And so the trust is being provided oversight by an institution. An example would be Northern Trust. That's one of the more common ones that serves trusts across the country. And Northern has a compliance department, and an increasing compliance department. As rules and regulations from the federal government continue to increase, needs for compliance continue to increase. And the compliance department is overseeing the decisions made by trust officers who are serving as decision makers on behalf of the trustee, which is Northern. And that they're basically overlooking to make sure, are you doing your role and are you protecting Northern? And then there's marketing involved so that they can bring in business to Northern. There's shareholders at Northern and or at other corporate trustees. And they're also an institution that's gathering assets under management. So there's a lot of moving parts in that play into how they market their services, and once the assets are coming in and the trusts are under the oversight of a corporate trustee, there are departments within that corporate entity that are influencing decisions on the trust. You also have individuals that can be served as trustee. You can have co-trustees. You can have 3 or 4 trustees. I've seen as many as 6 trustees on one trust. So that is not defined in any particular way. There's pros and cons to having multiple trustees. There's pros and cons to having a corporate versus an individual. And we'll talk about that a little bit more as we go through this. But you would, and sometimes people do trustee where there's an individual that is co-trustee with an institution. So there are a myriad of ways to do this, and it's primarily driven by the situation of the family and what are the needs of the beneficiary and what is the ability of a single trustee or the individuals that are serving as trustee, and how a corporate trustee might fill in any gaps there.
I want to just jump in real quick, Allison, and just clarify that. So you can have a institution named as a trustee, and that's very often referred to as a corporate trustee, or you can have an individual named as a trustee, and that would be a person. Or there's these myriad of other ways that trusts can be governed, and you're talking about those myriad of ways right now. Allison, would you talk a little bit to the trust protector piece and whether that needs to be someone that's a third party from, like, in a different firm from the trustee? How does that trust protector role work?
Yeah, so in order for the trust protector to serve their role as oversight of the trust and how the trustee is performing, you would want it to be separate, someone else. And typically we see individuals serving as trust protector. It's not always the case, but typically. And that goes to also the fact that oftentimes the trust protector is serving voluntarily. They aren't always compensated. Sometimes they are, but not always. Their role is minor in comparison to the trustee. They typically only come in when there's an identified problem by the beneficiaries. They're not an active player on a day-to-day or even year-by-year basis. But when there is a problem, instead of the beneficiaries having only the trustee to go to and the trustee holding the ultimate decision-making power, this provides an outside third party to be the the mediator, negotiator, and ultimately hold accountable the trustee in a way the beneficiaries typically aren't able to. So yes, a third-party person as the protector, usually an individual, but can be a corporate entity. Great questions. And so then in addition down here, we have some others that are real players in trust decision making. And we often call, when we refer to spouses, we talk about the pillow talk. And if anybody has seen some of the Jane Austen movies, Sense and Sensibility in particular, you hear how the spouse of the brother and the heir to all of the property of the deceased father talks her husband out of giving anything to his half-sisters and stepmother. And we have experienced and can tell many stories about how spouses have influenced beneficiaries and the relationship that they have with trustees. There's also spouses that are very helpful in those relationships. So I've seen both ways, but they're a part of this, whether they're in the document or not. And the advisors are also providing advice to beneficiaries, and so they're players in this. And then remaindermen. And remaindermen are only applicable for trusts that go on beyond one generation. So oftentimes there's trusts where they'll have a named beneficiary, and then once those beneficiaries pass away, it goes on to their descendants, and so on and so on. Well, all of those after that first generation of beneficiaries are typically referred to as remaindermen. Well, a quick story to illustrate that is I have a family where the trusts are in the second generation, and third generation has often piped up if they feel second generation is receiving too much in distribution from the trust, and in particular, if a red Ferrari gets purchased, it sends the remaindermen in a tizzy. So they can be influencers on the trustees' decision-making when making distributions from the trust. So because the trustee has to be mindful of them as well. So these are the players when we're talking about trust, or the potential players that can be involved. And let's go ahead and talk about now some of the roles and responsibilities of the two most important players. And the first one is that of trustee. And the trustee must understand the intent of the settlor. They can read documents, and typically corporate trustees, that's all they have to go off of. They may have never met the settlor. Individual trustees are often chosen because they have a relationship with the settlor. But either way, they have an obligation to do their best to understand what was the intention of the settlor and what's the letter of the law in the trust, and maybe, ideally, what's the spirit of the law that the settlor intended, and how that trust would interact with the designated beneficiaries. The trustee also has an obligation to plan for current and future beneficiaries, and that's what I was referring to as the remaindermen. Managing investments of the trust are the responsibility of the trustee unless that investment management has been delegated to an outside party. That delegation can be made by the settlor. The settlor can arrange the trust and say, I want outside investment counsel on the investments of the trust that reports to the trustee and beneficiary. Typically, we see the trustee is also making the investment decisions on the trust. Certainly at Northern and Wilmington and other corporate trustees, they are playing both parts by and large, for the most part. And where we see delegation of management is typically with the individual trustees. Now, there is a growing trend that we're seeing, especially with smaller banks, that they will accept the trust assets and the role of trustee, but will honor a delegated management of those investments because they're trying to get more business. it's more financially valuable and profitable for the corporate trustees to play both roles. And you'll often see J.P. Morgan as an example I worked on recently, where the trustee is a J.P. Morgan trust officer, and they've purchased J.P. Morgan investment products. And so that's a very good relationship for J.P. Morgan. And that's an example of how that can be done. And then the trustee also, by law and by the trust document, typically must be transparent and communicating with the beneficiary. And they have to report to them. They have to show them how the investments are doing. There are laws there. There didn't used to be, but there is more governance now, and it increases so that the beneficiaries have access to what's going on, what is the trustee doing, and how is it performing for them. So that's a snapshot on the role and responsibilities of the trustee. And now let's look at the roles and responsibilities of beneficiaries. And this is not written out. This is what Kristen and I have defined as the role and responsibilities of beneficiaries. And the reason we have defined it as such is because we've seen that the beneficiaries who have a positive experience with their trust have managed that relationship according to these foundational principles. And the first one is, which may seem very obvious, but surprisingly happens not too infrequently, we want the beneficiaries to understand the terms of the trust and the settler's intent. Oftentimes, mom and dad or grandma and grandpa don't talk about what they're planning to give their children or grandchildren or great-grandchildren. There's sometimes trust set up for individuals who never met the settler, never met the person who set it up. But we have found it critical to the beneficiary's success that they understand the terms of the trust. And if they can't read the legal document that created the trust, they should be sitting down with someone who can interpret it for them. Very, very important. The most litigation I've seen has come when the beneficiaries don't understand the trust document. The next is to know what type of beneficiary you are. As a beneficiary, to understand what kind of beneficiary do I want to be? And that might sound strange, but you do need to define yourself as this part of my identity. Do I want this to be a part of my lifestyle subsidy? Do I want this to be a philanthropic experience? How do I want these trust distributions to impact my life? And am I going to be proactive or am I going to be reactive? And whatever it is you choose, so be it, but know what your options are and be educated about what you decide to do and how you interact with the trust. I've seen beneficiaries interact in a myriad of ways, and all of them have worked for different people. So there's not a right or wrong per se, but just understanding and defining that for yourself and what works for you. And then thirdly, it's really hard for a beneficiary to have a good experience with their trust and, most importantly, their trustee if they don't have a foundational knowledge of investing. Again, the litigators that I work with, they are very busy with beneficiaries who don't understand the markets, that don't understand diversification, that don't understand concentration. And so they're picking fights and spending a lot of money on things that they don't win in the end, and they're driving down the road of fights that will later, in an expensive way, be shown how it was inappropriate. And we'd like to help them understand what they can expect before it happens, so that they don't get unexpected expectations that aren't met and disappointment that doesn't need to happen. So foundational knowledge of investments is important.
And Allison, this doesn't mean that there has to be a master's degree in investing. We're really talking about understanding some basic concepts so that the beneficiary can be an equal partner at the table in conversations with their advisors and with their trustees.
Yep, we want them to be able to read their reports. We want them to be able to understand what a diversified portfolio looks like, how to look at fees, the very basic 50,000-foot level. They don't need to look at money managers. They don't need to understand how to choose stocks. Right, it's not a master's level. We have beneficiaries who are artists, who do not watch MSNBC, don't know what Bloomberg is. That's okay. But they should understand some of the foundational components of a portfolio that they're getting the reports on. And then lastly, we talk about the developing a productive relationship with their trustee. It is very hard for so many families who they've been working with their parents for a long time, their parents pass away, and now they have a trustee who is acting like a parent but isn't their parent, and who's making decisions that impact their lives and livelihood perhaps. They tend to be hostile relationships if they don't work at it. And we've had to work with a lot of beneficiaries to help them help the trustee have a good relationship. It can go both ways. But if the beneficiary understands that they are responsible for playing their part in developing a good relationship, having good communication skills, being proactive, responding to their requests from the trustee, reading the reports, having conversations, asking questions, those things help that relationship be a positive one for both the beneficiaries and the trustee. So both parties have a role to play. Let's go ahead and turn it over to Andrew for some polling questions that we've put together.
Great, thank you. So one of the things that's, as you know, a hallmark of the Family Business Network North America events is that we always want to have it be interactive and get your input on different questions. So our first question is just to get a sense of where you are on this question, which is, what is the primary challenge facing a beneficiary? So from your perspective, what do you see as the primary challenge facing a beneficiary? So when you're looking, you can select one of these options using your mouse, and we will see the results after we get those in. So understanding responsibilities of the trustee, managing the relationship with the trustee, the lack of ability to skills to manage the relationship, or the lack of trust between themselves and the settlor. So make your selections, and then we'll get some feedback from everybody who's on our call today. All right, so it looks like the understanding the responsibilities of the trust and the beneficiary is in the lead with lack of ability and skills to manage the relationship. How do you guys feel about that, Allison and Kristen? Does that resonate with your experience?
It feels spot on to me. The two things that Alice and I see happening a lot, and that we work with on the beneficiaries that we have the chance to work with, is that there's two components. It's foundational knowledge and skills, and it's being in relationship. And you have to have both in order to really be a successful and engaged beneficiary. So I'm not surprised. It's interesting to see the breakdown overall, but that part doesn't surprise me at all. Allison, do you have any extra thoughts?
Well, it's certainly understanding these responsibilities. If both the trustees and beneficiaries really understood their roles and responsibilities, we would not have trust litigators. So I absolutely agree that that's the most challenging and what we spend our time on the most. And then the rest are symptoms of the
Yeah.
first one.
You know, I think sometimes families feel like the structure, whether it be a trust, whether it be a board of directors, or, you know, whatever that structure piece, they think that that's going to solve the relationship problem.
Right.
And really, you know, the relationship problem will seep into any of the instances where they have to be in relationship to each other. So I think it resonates with that.
It absolutely does. And I love that when I've had clients sitting in our conference room and they say, well, I don't know what the answer is, but I'll be dead, so it doesn't matter to me.
Right.
And it breaks my heart. It's funny after the fact, but it breaks my heart that that it feels so insurmountable that the settlers and the parents just can't even go there. And there's easier ways to do it, and we'll talk about some of that here today. So if you feel overwhelmed, don't be. There are solutions, and you might not gravitate to those on your own, but there are solutions out there to help us navigate through this.
So I want to talk a little bit about the unintended consequences and challenges of being a beneficiary. We know that there are a lot of blessings that come with having resources, and being the beneficiary of a trust often allows you to have access to more resources, and there are many, many blessings in that. And there are also many challenges of being a beneficiary of a trust. And Allison and I see this really consistently in some of the workshops that we run where beneficiaries come together for a couple of days, and we're focusing on those foundational skills and the knowledge that they need and the relationship skills that they need to build in order to be successful. And one of the things that we see and that we hear is that for beneficiaries to be together in a room where they can actually discuss the challenges and not feel like they're being subject to the poor little rich girl or poor little rich boy looks and stares and comments from other people, it's incredibly liberating for them because there are a lot of unintended consequences and challenges, and it's by building the skill set and the awareness of what those are that beneficiaries can really learn to thrive and really become empowered and engaged. So some of these actually Allison alluded to just a little bit ago. One of them is this feeling of resentment for being parented by a trustee after the settler has passed. And this is one of the challenges that arises and that is particularly present when the relationship between the trustee and the beneficiary isn't a solid, equal where there's communication on both sides and both people are engaged in making it work. So that's definitely one of the key places where a lot of beneficiaries get tripped up and start to get angry. Another one is the sense of entitlement when expectations around what the trust is aren't properly defined. And one of the key ones that we see come up is the misbelief that the money that's held in trust is their money. The money that's held in trust is actually, it's owned by the trust, and the beneficiary receives the benefit of that trust. And so it may seem like a subtle distinction, but it's a significant one when you're talking about having access to those resources and what the rules around having access to those resources are and why it feels like someone else is keeping you from your money. That there is a clear distinction in who actually owns or what actually owns the money. Another piece is and Allison alluded to this, the lack of understanding of investment portfolios and the return and their return, and that can create expectations that are out of whack and unnecessary lawsuits or removal of trustees because of that. So again, this goes back to having some basic financial knowledge that even if this is not your bailiwick and numbers and investing is not something that totally lights you up, I know that it's not for me, and I have to work to get the basics in place so that I really feel like I can be conversant in the ways I need to be conversant so that I can be engaged. And this is an area that even somebody for whom they just are, they don't want to talk about the money, then they may be at a place where they just throw up a huge curtain around that and don't want to actually discuss the more technical aspects. It's an important thing to get to a place of having some common vernacular and common knowledge around investing and what they can expect, because it's a place that you can avert a lot of lawsuits and other tension and frustration.
You know, and on the positive side to that, if you've got someone who won't talk about it, and this has happened many times. I've had many parents come in and say, I can't get my children to listen to me. They don't spend the time to sit down and go over these reports. I had a gentleman in just the other day, and he has adult children who are successful in their own right, but they will not spend any time on the family trusts, understanding them, taking any responsibility for learning how they're being invested, and it is frustrating. And especially when they're reaping all the benefits, but they're not doing any of the work that we've outlined are their responsibilities as beneficiaries. And some of the things that we've done, which is, a caveat here, it is completely dependent on whether or not the trust document would allow for this and where you are in this use of the trust. But if you as the parent are serving as trustee and you have discretion over distributions made, well, guess what? You don't have to make a distribution if the kids are not responding in a way that you feel is healthy or collaborative or proactive. And so we have at times halted distributions or put stipulations. If you want this, here is the ABCs of what we expect out of you before a distribution is made. So there's one example.
Can I jump
Another
in with a quick point there? And
Yeah.
that is to just say that a lot of times it can be helpful to understand what is the emotional message behind what they're trying to say to me when they say that I'm not going to engage in learning about this, and understand the emotional message behind it too, because I think that's, if we don't address the emotional message, it's harder for that individual to engage.
Absolutely, which is perfect for the next point. And the second is bring in a third party to come help assess what's the barrier, what's keeping this beneficiary from being able to be engaged in this. And I've seen the gamut of embarrassment or just resentment that it's causing something, it's providing another tension somewhere else in their life, and so they just can't deal with it. Especially in marriages, it can have a challenging impact on marriages when one spouse is making more out of the trust than the other spouse is earning at their day job. So there's a lot of different influencers here, but you're absolutely right, Andrew. You do need to get to the root of what's causing the problem and work towards that. So we now have another poll question for the group. Let's go on to that.
Excellent. So the poll question this time around is, what is the primary challenge that's facing a trustee to interpret the settler's intent, to navigate the relationship with the beneficiary, to understand their roles and responsibilities, or to deal with litigation? So take some time and make your selection. Click on the option that is the best answer from your perspective, and we'll see what people think. All right, navigating the relationship. Again, we come back to navigating relationships is a real challenge in family situations. How do you guys see this one? Is this what you would expect?
Absolutely. And I think, it almost to the point where I think in the trustees' roles and responsibilities should be some emotional training. It is such a challenge.
One of the things that we actually hear, that Alice and I hear from trustees, is that that they look to us to come in and to actually to help to be a part of the system and to help the beneficiary learn what they need to learn, as well as to help be a translator, because the relationship piece is so hard, particularly for people who are maybe more technically trained. A lot of trustees are lawyers, and that's really their come from. It's not necessarily to go build relationships and not have a high level of emotional intelligence. So I think that this is if someone wants to do an offshoot training, I think that somebody could create a training for trustees to really help them thrive in this relationship as well.
And the only other thing, since no one voted for litigation, let me just say, as someone who serves at our firm, we serve as expert witness to trust litigators. It is very prevalent. And if you're not worried about someone in your family suing, and many times I've heard parents say, oh, my family wouldn't do that. And within 6 months of their death, the kids are fighting each other. But also keep in mind that the fear of litigation drives trustee decision making. And that compliance department I talked about at corporate trustees, the desire to avoid litigation often rules in influencing their decision making on distributions. And so they'll be very, very conservative and make a decision that would be really hard to sue them on. And the beneficiary often gets less because of that fear of litigation that's driving the trustee. And it's a reasonable one. They can lose their shirts if a beneficiary gets super fussy and gets a really good lawyer. So don't underestimate the power of litigation and its role in trusts. Well, with that said, let's move on to some more on this unintended consequences and the challenges. We've talked about some already, and one of the things I wanted to mention that ties into liabilities and litigation is that the trustees, as an individual, so if you name John Smith as trustee over the trust for your children, he's personally liable if something goes wrong. Let's say he places a bet and he buys big on Apple. He shouldn't do that, but the beneficiaries won't complain if Apple goes up. They will complain if Apple goes down, and they can sue him for lack of diversification. If they win, the trustee is responsible for that. And because of that liability, they tend to have insurance to cover themselves. If you're out choosing a trustee, you need to ask about what are their insurance protection that they have. What are the levels of insurance that they have? The other challenge that is the removing of a trustee. And lawyers are getting better in their documents today versus 10 or 20 years ago with providing easier avenues for the beneficiaries to remove a trustee. The reason is because trustees would get into their role, they knew that nobody could kick them out, and so their behavior was consistent with someone who was a dictator. and so we want to be sure, is your trust document allowing for a fairly easy removal of a trustee so that someone doesn't get too much power, and then something there to help protect against the beneficiary kicking out a trustee because their particular request wasn't granted, so they'll go find someone who will grant it. You got to balance that out. And then, of course, we're always on the lookout for conflicts of interest. We wanted to provide you with a quick case study that will illustrate the points that we've made today. And that is, here we've shown here some players. We've got the Smith family. We have a trustee who is a family member, the daughter, plus a trust company. They serve as co-trustees. The family did not choose a trust protector. The family's funded, the parents have funded 5 trusts, 1 for each child, and then those trusts continue down the family line. We've outlined here on the left, you'll see the distribution guidelines. It's the typical health, education, maintenance, support. They call them the HEMS guidelines, very standard. And one thing they added was that a trust can distribute more than 5% out of the trust at the trustee's discretion. We're okay with that, so let's say, okay, that's what it is. That can get tricky with remainder men, but let's go on to the next slide. The real challenge with this family is that when they set up their estate planning, each trust was going to be funded with $1 million. Well, the 5% annual distribution, let's just be easy on numbers here, it's $50,000 a year to each beneficiary. Well, where does it get sticky? It gets sticky because here we are 15 years later. The parents' assets are now worth significantly more, and each trust will be funded with $6 million. That's the equivalent of $300,000 a year to each beneficiary. The challenge? Each child is earning an average of $75,000 a year in income. Big game changer to all of a sudden, with the death of their parents, to start receiving $300,000 a year. So let's go on to the next slide here. So we've talked about the roles, the rules, the challenges, the unintended consequences. You've got to come up with a plan with good advisors that work for your family. And you need to ask yourself the questions that we've highlighted here. And in particular, don't come up with your plan, put it on the shelf, and leave it. You've got to make sure that you go back and revisit it because your family dynamics will change. You could end up with children winning the lottery but not being ready for it. So we want to prepare heirs. How are you preparing your family? How are you preparing the heirs? And the heirs, keep in mind, with people's ages now, they're living a lot longer. You may not be spending this until great-grandchildren are around and receiving the benefit. So there's a lot to think about, a lot more than an hour necessarily can provide, but we hope that this has helped you see some highlights, questions to be asking yourself. And as we wrap up here, you'll see in the what we feel are the 3 most important components to be looking at in your personal planning. Kristen?
So, so the most important things we think are that both the trustee and beneficiary must fulfill their roles. And this is something that Allison hit on earlier, that if everyone is in their role, then they probably wouldn't have trust litigators. That the world of trust is constantly evolving, and to know that it's not a static thing. I mean, think about where trust started back in the Crusades and where we're at today, and the laws and the regulations around that are continually changing. And that far, far and away, the most important component of this whole thing is the power of the relationship, and that both trustee and beneficiary and, if possible, other players in the trust dynamic really be actively looking at and trying to improve the relationship and the communication around this. Because money can be tough stuff to talk about, and when you wrap it all up in a box and try to pretend like it's just about the trust, you're likely going to be setting up the dynamic for a bumpy road there. So Andrew, I know that we, Allison and I, both are G2 members in a family, and we don't have a lot of time, but would love to open up the floor for you to ask us any questions that might benefit everyone who's listening.
Sure, and there are a number of questions that have been kind of coming in along the way. I guess one interesting thing for me is, how did your family prepare you and educate you as a beneficiary? Is this something you guys just decided, you would take on yourself?
Allison, do you want to go first?
Sure, yeah. So our family has a family business, and we have some dynamics that are unique to us. And one of the things that my parents started doing years ago was talking with us individually about what we were interested in, what we were trying to pursue in our personal lives. And then my parents would talk to each other and their advisors about how did their planning fit in with what each of my siblings and I were trying to do in our own lives, which I really, really appreciated, that versus it being a top-down approach, they made it a bottom-up approach. That was really helpful, and an open dialogue.
And one of the things that my family has done, they certainly have not taken on a formal education, but we have an annual family meeting, and at that meeting we generally have one of the advisors who advises my parents come in and talk about some aspect of their estate. Last year was a big year with all the estate changes, so we had a big meeting with their lawyers. And we spend a lot of time talking about relationships. The biggest component of our family meeting is actually connecting with each other, talking about what's working, what's not. We talk about the resources in our family, and my parents are very open about how they are sharing those resources and with each of us in different ways. So ours is much more relationship-based, though I think that we have an opportunity to continue on a path of getting more of the basic knowledge and skills to the rest of my siblings that Allison and I talked about here today.
Well, since you're both Next Gen members, what advice do you have for Next Gen as they prepare for being a beneficiary?
I would say the biggest thing that comes to mind for me is you can't turtle and pretend like it's not there, or pretend like you don't need to know, or just get overwhelmed by it, and that there's nothing wrong with sitting at the table and saying, I don't understand what you're saying. Can you please help me understand that? Can you say that to me differently? There's nothing wrong with hiring an outside advisor to help you understand that and to help be an advocate for you so that you can learn and build those muscles so that you can confidently sit at the table. And that the most important thing is that in order to make this a positive experience, you have to choose to be engaged and get empowered. And that is by far the most important element to thriving as a beneficiary.
Gotcha. A couple of questions. One's fairly quick. These came in over the question. The question is, can a trustee also be a beneficiary? And then I have a second question after that.
Yes, they can. Under certain situations, they certainly can. And in the example we quickly highlighted, one of the daughters, a G2 member, is co-trustee with a corporate trustee, and she is also the beneficiary of that trust. So yes, they can.
Gotcha.
You have to be careful with the type of trust it is and with the kind of investments and how they're registered. There are some complications to it, but the short answer is it's possible.
And actually, that's the situation that I am in. I am a beneficiary and a trustee on my own trust. So I'm co-trustee with Northern as a corporate trustee. So they manage the investments, and then I'm a trustee on that trust. So the other question, another question that came in was really, obviously, many families are really often concerned about developing a sense of entitlement in the next generation. How did your families fight against this kind of sense of entitlement, and how have you seen other families deal with that?
The fast answer for my family is that there's some magic that my parents have together that I'm still not exactly sure and trying to decode how they do it, but they have some way of working together that so the answer is yes, they have actively worked against building an attitude of entitlement in me and my siblings, and I'm not sure that it was so conscious on their part as it was their natural parenting style, that we always were expected to work and to contribute and to earn income, and all four of us do at this point support our own lives. And the way that they have set up their trust structure or their estate structure is that their estate doesn't distribute until their passing. And so while we receive gifts from my parents' estate, none of us have a trust that's actively distributing. So each of us is responsible for our own livelihood.
And to add to that, there's a great book called The Entitlement Trap by Richard and Linda Iyer that are parents that have written some great ideas on how to, and maybe Kristen, it'll decode what your parents' magic is, but helps to have you have healthy family systems that will curb entitlement, and it really has nothing to do about money. It has to do about building relationships and values and focus on things that are not economic so that you can put the economic in a healthy bucket.
Excellent. Well, thank you to Kristen and Allison for a really engaging webinar, and I know it helped me even with my own understanding of my trust, etc. So thank you to you, and for those who have additional questions, we can submit your questions to them offline, and we'll try to get some answers for you. Just a quick update on some upcoming webinars. We have one, Finding the Formula, Engaging the Unengaged Family Member, to pay or not to pay family governance and board compensation, on August 26th and October 28th, respectively. Our next conference is September 22nd and 23rd in San Jose, California, Innovative Families and Family Businesses. And November, we will have an event in Miami that I believe it's the 21st and 22nd in Miami on strategic governance for families. So hope you can join us for all of those. Thanks again for participating, and we'll look forward to seeing you at an event soon. Thanks.